the BASL Seminars Committee on the topic Framing of Issues in Civil Actions. This is the 62nd webinar of the first webinar series hosted by the Bar Association of Sri Lanka and conducted on the Zoom platform. And for those of you who are unable to register on Zoom, hopefully you're joining us on our YouTube live stream on the BASL YouTube channel. Before we start, we would like to thank the Seminars Committee of the Bar Association, the Chairman of the Seminars Committee and the Secretary of the BASL, Mr. Rajiv Amarasuriya, Convener of the Seminars Committee and the Assistant Secretary of the BASL, Mr. Pasindu Silva, and co-conveners, Mr. Pandula Vanniyarachi, Mr. Ushanu Beratna, Ms. Anne Devananda, and Ms. Nikini Mapitikama. I would also like to take this opportunity to thank the President of the BASL, Mr. Salia Piris, President's Council, and the other members of the Management Committee of the Bar Association for their support and guidance. As I've already mentioned, today's topic is on framing of issues in civil actions, and it gives me great pleasure to introduce the esteemed panel and moderator for today. Firstly, let me introduce Mr. Vivekanandan Puvitharan, President's Counsel. Mr. Puvitharan, who initially apprenticed under Mr. G.F. Sethukavala, President's Counsel, was called to the bar in the year 1991. Thereafter, he joined the Attorney General's Department in 1993 and served as a State Counsel till June 1998, after which he commenced his own private practice. He was awarded Silk in the year 2017. Mr. Puvitharan was the editor of the Colombo Law Society and was a member of the editorial committee of the first Hulstov Law Journal of the Colombo Law Society in the year 2008. He was also elected as the Vice President of the Colombo Law Society. Mr. Puvitharan also served as a lecturer at Sri Lanka Law College, where he lectured on the law of property and civil procedure. Our second panelist is Mr. Chanak Fernando. Mr. Fernando is an old boy of St. Thomas's College, Mount Lavinia. During his time at Sri Lanka Law College, he was elected as the President of the Law Students Union in the year 1990. He was a past President of the Colombo Law Society and served as an International Commissioner of the Sri Lanka Scouts Association. He was also elected as a volunteer member of the Asia Pacific Regional Scouts Committee of the World Organization of the Scouts Movement from year 2012 to 2018. He was recently appointed as the 21st Commissioner of the Sri Lanka Scouts Association. Our final panelist is Mr. Murshid Maharov. Mr. Maharov holds a Bachelor of Laws from the University of Colombo and has been in active practice as a civil counsel, covering a period of more than 27 years. At the early stages of his career, he started as a junior counsel at the chambers of late Mr. Chula de Silva, President's Counsel. Today, he practices in areas of commercial and civil litigation, predominantly shipping law, admiralty law, commercial arbitration, and company law, in the commercial high courts of Colombo, district courts, and appellate courts. Mr. Maharov was also the chairman of the National Law Conference in 2017. The moderator for this session is Mr. Shamir Zawahir. Mr. Zawahir is an attorney at law practicing in the original and appellate courts of Sri Lanka. He also commands a practice in the field of arbitration and is a member of the Chartered Institute of Arbitrators of the United Kingdom. He had his primary education at Trinity College, Kandy. He holds a Bachelor of Laws from the University of London and was also a triple gold medalist at Sri Lanka Law College. He convened the National Law Conference in the year 2017 and the IT Committee of the Bar Association of Sri Lanka in the year 2000. He lectures public law at the Center for Professional Studies, Colombo, and is a director of Justice Sector Reform Program of the Ministry of Justice. With that, let me remind the members joining this session by Zoom to send in their questions through the Q&A chat box to reach the moderator. I will now hand over the proceedings to the moderator. Over to you, Mrs. Zawahir.
Thank you, Tanuja. Today forms part of a very important discussion in civil law, which is the raising of issues. I think all of us as juniors would remember that raising issues was one of the first things that our seniors taught us. I remember Mr. Maharov teaching me to raise issues on the second day of joining, and I remember him telling me that raising issues is one of the first and most important things you will learn as a district court practitioner. And I think most of us are entry into making submissions on our own, and of course, being on our own feet in court is when our seniors told us to raise issues. And all of us would remember writing those down from our senior to start with, and finishing with that last line. If any of the answers herein are referred to, answered in favor, does the plaintiff have the right to obtain the reliefs prayed for? I think it's hardwired into every original court practitioner's brain. So I can't state how important the raising of issues are as more or less the foundation of an original court practice. And it is therefore a privilege to moderate this session with three very eminent practitioners and for us to gain their knowledge on this area with regard to this vital aspect of the practice. So today's session, our eminent panel would be dividing the areas to cover a wide range of the question of raising issues, from the legal academic aspect of it, as well as the practical aspect with regard to raising issues, and as well as the changes in the law over the last few years and how they have affected the issue of raising issues, if I may say so. So I would firstly like to invite from our panel, President's Counsel, Mr. Puvidaran, who will speak on the changes brought about and the salient aspects of Act number 8 of 2017 and the amendment brought through that, as well as the effect it had on the law relating to issues. So I would now like to hand it over to President's Counsel, Mr. Puvidaran. Sir, you may take over. Sir, I believe your mic.
You are muted.
Sorry. I think Mr. Chanak Fernando, we decided to start with this. So I think you will have to give it the mic to Mr. Fernando.
Yeah, I think
Chanak Fernando will be commencing
Shamir
session
So,
on the.
Shamir did a.
I did a small switch with regard to the two counsels.
Small switch. That's okay. We can.
Mr. Chanak Fernando, sir, will be speaking first on Act number 8 of 2017, and President's Counsel, Mr. Puvidaran, will be speaking on the practical aspects, I believe. Mr. Chanak Fernando, sir, if you may take over.
Yes, thank you, Shamir. I think that was a good icebreaker, because you had done it intentionally, most probably. Anyway, thank you, Tanuja Migahavatta, for the introduction. And my batchmate, Mr. Puvidaran, my law college mate, Murshid Maharov, and of course, Ms. Shamir Zavahir, the moderator, and my dear fellow colleagues of the bar. It gives me great pleasure this evening to share some thoughts and knowledge about framing issues. My dear friends, prior to know how to frame issues, Labour Tribunal precedents, and those issues are answered
I think Janaprit Fernando's, yeah, Shamir.
Yes, is it Mr. Fernando? Did he log out? Because I believe I was wondering if it was a technical on my aspect. Can I be heard?
You can be heard.
Right. I think Mr.
Mr.
Chanak Fernando may be
yeah.
facing some technical issues, I believe. I'm wondering maybe if we'll let Mr. Fernando sort it out and come back. And
Yes,
sir, Mr. Puvidaran, shall we
Yes.
start on your session, and then while Mr.
Right.
Fernando fixes it?
Yes. Then
Yeah.
we will start on it.
Yes. So till Mr. Fernando can sort out the little technical glitch, if I may invite the President's Counsel, Mr. Puvidaran. Sir, Mr. Puvidaran is speaking on the practical aspects in regard to raising issues, more the do's and the don'ts of raising issues, if I may say it so myself. Sir, would you like to take
Yes.
over and speak?
I will. Thank you, Shamir and Megawata, for that nice introduction, and also all the other viewers who are there. Good evening to you all. Now let me start on the raising of issues. When we say raising of issues, we must always think there is this admissions, recording of admissions, as well as raising of issues. So when raising of issues, before raising of issues and admissions, there is another aspect that we must always be mindful, is that when drafting of pleadings, we must always have that in mind, that we are going to raise issues in the case, because the issues are the main part of the case, where the case is going to be decided and the judge is going to give a judgment on the issues that are raised by the parties. So when we draft the pleadings, we must always have that in mind, that what are the issues that we could raise at the time of trial, beginning of trial. So that we must have that in mind when we are drafting the pleadings, even whether it is plaint or answer or any other documents, even marking, we must have that in mind, because I will come to that later, because even the issues can be raised not only on the pleadings, but even on the documents and other items that are there. So we have to be mindful when we are drafting pleadings. Then when we come to admissions, because now I think later Mr. Janaprit Fernando will do that. Now, according to the new amendments, even the previous one, there is the matter called, that is, we have to always start with admissions, recording of admissions. So recording of admissions are always reduce our matters that has to be proved in a case. So we have to be mindful, we have to see both sides pleadings. The counsel must see the pleadings, and we must try to record as far as possible the most number of admissions that we should be possible. Because then we are crystallizing our case, we are narrowing down our case to a few issues that are in dispute between the parties. And especially for the want of proof, if we record the admissions properly, and then our burden of proof will be reduced, and leading of evidence, and even we can cut short, the time, the delay, large delays also can be sorted out. So that is other aspect, that we must be always mindful that admissions are most important, like, it's like important as raising issues. So it is always be mindful of that. Then we will come to now recording of issues. And we all know the issues are the things that the court is going to decide on the case. Now, what are those issues? Issues means the parties are at variance. That is the matter that is at variance. The parties are unable to settle on the matter. So then we are raising those as issues. So when we are raising that as issues, sometimes some counsels, they have the practice of raising it each and every pleadings as they turn it to a question of law, question of as issues. So that practice we have to, we should not follow that practice, because always the issues we must see that the judge should be able to properly and must have few issues which will crystallize our case before the judge. So we have to be mindful what is our case and what is the other party is disputing. So on those matters only we must raise the issues. The other matters, those are not relevant, should not be, the irrelevant things should not be raised as issues, because those are, you can leave those things in evidence, but it is not necessary to raise it as an issue and ask the court to answer those matters at the end of the judgment. So that is a very important issue. Here then there is the earlier amendment. I think Mr. Chanak Fernando again, he will come and do that. So earlier one, it had parties, we generally, those days, we on our feet, we stand up and raise issues, both parties. So other party doesn't know what we are going to raise, but they can guess it. Because how they can guess it? From the pleadings only, generally they raise issues, and there are other material facts on the documents and other issues, we can raise issues. Then when the issues are objected also, from the feet, we have to object to it. But now with the amendment, it is mandatory that we must file written issues. It's good, because then the parties can know what is the other party is going to raise and what is the issues, and they can come ready to object to those issues, and or they can allow those issues. So here, now that parties are raising issues, but the judge also, in the earlier one, judge also have the right, and also he is also duty bound to raise issues. There are judgments to say that it is the prime duty of the judge to raise issues. But since it is an adversarial system, the parties are also have a right to raise issues, because this is a matter we are presenting it to the court. It is not an inquisitorial system. So we have this adversarial system. In the adversarial system, parties, they can raise that issues whenever they want at the time of trial, and thereafter, if those issues are not adequate, not enough, and if the judge thinks that those issues are not adequate to come for a decision, so he or she also can raise the issues thereafter. Now we know that issues are generally raised. We think that it is the plaintiff's issues, and then we raise it as defendant's issues. But in fact, in court, we all know at the pre-trial stage, even before that also, the issues are numbered. Once it is considered and finalized, and then it is numbered. So at the time of numbering, we all know it is not numbered as 1, 2, 3, 4, 5 plaintiff's issues, then 1, 2, 3, 4, 5, 6 defendant's issues. No, it is numbered continuously, 1, 2, 3, 4, 5, 6, 7, 8, up to the last issue, it is numbered continuously. That is because those issues are considered thereafter, after raising and considering, those issues are considered the issues of the, in that case. Whether it is raised by plaintiff or whether it is raised by defendant, those are the issues that is going to decide the case. So this is very important thing, because we must understand that basic thing. Because here, whether the plaintiff, if plaintiff failed to raise an issue which he has to prove, then the defendant cannot simply sit back and say, no, now that plaintiff has failed to raise that issue, therefore, that is his fault. But if the plaintiff has to prove that matter, then it is always, we must raise, the other party must raise that issue and put the plaintiff, whether it is his issue or the defendant's issue, they must put that issue and call the plaintiff to prove that. So unless that issue is there, the plaintiff is not going to prove that. So if the other party, whether it is plaintiff or the defendant, fails to raise some issue which he has to prove, and if he fails to prove that, then he might lose the case, then we have to, other party has to raise that issue, because the raising of issues, because here, this is the judgment. I just wanted to, in that aspect, I wanted to point out this judgment, which says 2 NLR 155, in that it was said that if the party doesn't raise that issue, then what will happen is that he has waived off that matter, and thereafter, then that is not in dispute. Is the that is how it will be considered. Then, when we take the other matter, the issues can be, as I said earlier, can be raised from the pleadings, from not only from the pleadings, but even documents, interrogatories, evidence, claim in reconvention, replication, and even sometimes if the judge thinks, no, there's some evidence need to be recorded to record some issues, then he also have the right to raise, call for evidence, and thereafter record those issues. So these are the matters that we have to consider when raising issues. This is, you can note down this judgment, Nadraja versus Daniel, 1999, 1 SLR 240. It was said it can be issues can be raised not only in pleadings but other materials, like what I said earlier. So this is one aspect of it. Then now we must also know that we generally make a denial in the answer, and mere denial without an issue will not be considered, because if we would have denied that fact, but if we don't raise an issue on that, then the court will consider that we have waived off that matter. That is also in 2001 BASL newsletter at page 5, it was, that judgment is reported. And the other matters are like, right now, the issues can be either, there is this preliminary issues, you all know, the preliminary issues are generally preliminary issues, either it is a pure question of law, and that should go to the root of the case. So if the preliminary issue is there, if it goes to the root of the case will be first, that issue must be tried, because otherwise the court is not going to go into academic exercise, like, if that issue is going to decide the case, there is no point in leading that evidence. So we also must know what is that issue, whether it will go to the root of the case. So if it goes to the root of the case, then we have to be mindful, and we must raise that, and we must take that up and say, this is the first, this must be tried first. So with this, then I think I will conclude, Shamir, and thereafter I will at the session is as a.
Yes, I'm here. I'm here.
You have come.
I thank
Okay.
you, sir.
Then, right, I will continue thereafter when questions come. Thank you.
Thank you, sir. Thank you for that very practical and concise and very detailed explanation with regard to the practical aspects of raising issues. I think most people severely underestimate that sometimes sticking to the basics and knowing your basics go a long way to win cases. And I think you did a great task of summarizing that in those 20 minutes. Thank you, sir. And now I would like to move on to Mr. Fernando, who was scheduled to speak first. Sir, you did commence, and I think you can continue from where we left off with regard to the changes and the aspects brought in by the amendment.
Yeah, thank you, Shamir. I think your dream came true because you want to get Puvi first, and anyway, you got him. Right. So ERSR Kumaraswamy in Law of Evidence, Volume 1. I think before we talk about issues or learn to frame issues or file issues, we must know what issues are. So this is what he says. Thus, in civil cases, a party to a litigation seeking to enforce a right or a liability against his opponent in order to get a judgment in his favor from the tribunal has to establish all such facts as constitute a right or liability. These necessary constituents of a right or a liability are called facts in issue if their existence is asserted by one party and denied by the other. Therefore, every fact which a plaintiff must prove in order to obtain adjudication in his favor, or which a defendant may prove in order to defeat the plaintiff's suit, becomes a fact in issue if the parties are not agreed as to its existence or non-existence. So, my dear friends, my dear colleagues, this is what an issue is all about. As Mr. Puvidaran very rightly explained, the entire case ultimately is decided on the issues that you frame. Therefore, one of the most important aspects of a civil case in the district court is the framing of issues. Now, if we look at the history of issues, in our Civil Procedure Code, sections 146 to 149 are the sections which dealt with issues. Determining of issues was in section 146 of the original Civil Procedure Code. Then section 147 stated that issues on law should be tried first, as Puvidaran also rightly said. And then 148, in the event a certain issue or issues cannot be raised without leading evidence, giving the judge the power to adjourn court in order to call up the evidence, summon the evidence, and then raise the issue. So by section 10 of Act number 8 of 2017, sections 146, 147, and 148 of the Civil Procedure Code were repealed. But you must remember that section 149 still remains. And section 149 is a very important section for all of us to remember, because this is the section which empowers a judge, a trial judge, before passing a decree to amend the issues or frame additional issues on such terms as court thinks fit. Therefore, my dear friends, in every plaint and answer, after you file this plaint and answer, and if there's replication, as Mr. Puvidaran rightly said, we have to either deny or accept or admit the averments contained in the plaint. If you don't deny the averments contained in the plaint or the paragraphs, then these could be recorded as admissions. And if an admission is recorded, you will not get an opportunity of rebutting that or leading evidence to the effect that that admission should not be considered. Once admission is recorded, that admission will be considered as an admission by both parties. When it comes to issues, there are issues of fact and issues of law. In 21 NLR, at page 51, in the case of Attorney General versus Punchirala, Sampayoji very rightly said that no court should refuse to apply statute law, even though there be no formal issue stated on the point. If necessary, the court should, in pursuance of provisions of the Civil Procedure Code in that behalf, frame an issue before delivering judgment. So this is with section read with 149, which I told you before, 149 of the Civil Procedure Code. And in 21 NLR is this judgment at page 57. Sampayoji very rightly says the issue set This is taking a very narrow view of the nature of a trial of the court of first instance. The issue said to be necessary would have reference merely to the construction of an ordinance, and no court should refuse to apply statute law, even though there be no formal issue stated on the point. So therefore, even though in your pleadings you do not have, you have not pleaded any legal matter, the learned judge can raise an issue, or even any parties to the case can raise an issue on law. Then, my dear friends, if we go into how this entire law changed, as mentioned by the moderator at the beginning, this entire law changed by Act number 8 of 2017. As Ms. Buidaran very rightly said, previously, we come to court on the date fixed for trial and we raise issues in court, surprising the other party most probably, but of course you cannot say surprising because the issues have to be restricted to your pleadings. You cannot raise issues which you are not pleaded. Therefore, any party in a court or your opposing party will be aware as to what issues or what matters will be raised as issues and what matters will be admitted as admissions. But the Civil Procedure Amendment of 8 of 2017 has made the procedure much easier for the lawyers, for the court, and even for the litigants. Now, if we look at this amendment, there is something called the pre-trial introduced in this, pre-trial proceedings. A new section was introduced known as Section 79A, which talks of pre-trial. The pre-trial, forthwith on an expiration of the time allowed for the filing of the answer, where replication is permitted on the last day of the time allowed for the filing of the replication, and whether the same is filed or not, appoint a date not earlier than 3 weeks and not exceeding 2 months from such date for pre-trial hearing to be commenced, either in the presence of all parties to the action or such parties as are present. Therefore, as per Section 79A, this is where the pre-trial comes into being. And in the same amendment, with regard to admissions and issues, Section 9 of the Act, which has introduced Chapter 17A and the new Section 142A, admissions and issues. 142A deals with admissions and issues. And it says, the parties shall tender their proposed admissions and issues in writing to the court registry 14 days prior to the date fixed for pre-trial hearing with proof of service by the submission of a copy of such admissions and issues to all parties. So earlier it was the list of witnesses and documents which we had to file before the trial, but now we have to file the issues, admissions, and the list of witnesses and documents 14 days prior to the trial, pre-trial, with notice to all parties. The Section 142B gives the trial judge the power to either hear on his own motion or an application, to either hear the pre-trial on the same day or even to postpone. The next important section in this amendment is 142D. 142D, at the pre-trial hearing, the judge conducting the pre-trial hearing shall have power to question the parties or call upon them to state their respective cases with a view to A, ascertaining jurisdictional issues, elucidating the matters in dispute, obtaining admissions of facts and of documents. Now under 142D, the judge has this power, and it is very important that we are aware of this. Because otherwise, if we are unaware of this, we will be taken by surprise when the judge requests parties and calls upon parties to state these matters. The next important section is the 142F. 142F of the amendment, which talks about at the pre-trial, the judge conducts the pre-trial hearing shall record A. The admissions by the parties of facts or documents or contents of documents. So under 142F is where the learned judge is given the power to record the admissions by the parties. Then further down in the section, under section C, subsection 2, any decision of the judge conducted the pre-trial hearing on any or all issues of fact or law and entering of the judgment in accordance with such decision. So therefore, all issues of fact and law, the judge is given the power to enter judgment in accordance with that. The next important section would be 142G. At the pre-trial hearing, issues may be determined taking into consideration proposed admissions and issues submitted in writing under section 142A, pleadings, interrogatories, and any agreement. So as mentioned by the previous speaker, Mr. Puvidaran, issues can be raised on the pleadings, interrogatories, and on any document or agreement. The next section, 142H, where the judge conducting the pre-trial hearing is of the opinion that the issues cannot be correctly framed without examination of some persons not present at the pre-trial proceedings or without the inspection of some documents not produced in the action, such judge may adjourn framing of issues to a future date, where the judge can summon that party or call for the documents to be examined prior to raising the issues. Therefore, you will see, my dear friends, that there is a lot of power vested on the learned trial judge with regard to the issues, and we as counsel appearing for either party should also be fully aware with regard to how to raise issues, at what point to raise issues, and when and how. Then if you go back to section 79 of the Civil Procedure Code with regard to the replication and further pleadings. So the issues as mentioned by the previous speaker and self, there are issues of the plaintiff, issues of the defendants, but all numbered, and then there are consequential issues. That is generally, consequential issues are generally arising out of the replication. And as you know, a replication is filed only if there is a claim in reconvention in the answer of the defendant. Therefore, that opportunity is generally given only if you have filed replication and you can raise the consequential issues. But in section 79, there is power, there is section 79 empowers that even except in the case of a claim by a defendant in reconvention, no pleading after answer shall be filed except by order of court on special motion to be made after due notice to the other side and before the day appointed for the hearing of the action upon such terms and to cause postponement of the hearing of the action as court shall think fit. Such order shall not be made except in the case of a claim in reconvention on the part of the defendant unless the court is satisfied on such motion that the real issues between the parties cannot be conveniently raised without such further pleading. Therefore, we have this section 79 which we can rely on. In the event we are not permitted to file our application since there is no claim in reconvention, counsel can make an application under section 79 of the Civil Procedure Code either by way of motion or in open court and get permission of court, leave of court to file further pleadings, and you can raise issues on those pleadings as well. Then another important aspect is, especially now with the pre-trial scenario, most of the judges, though attorneys have the habit of raising every paragraph, every argument in their plaint as an issue, the learned judges try to shorten them and then decide on the real issues to be decided upon. And therefore, I would urge counsel also not to raise every paragraph you have pleaded as an issue, but go to the crux of the matter and then raise issues which the learned judge has to focus his attention when he or she is entering judgment. So, my dear friends, these are some of the salient features with regard to the issues. and the changes, recent changes, recent in sense now it's 3 to 4 years, but nevertheless, the present practice on issues is in Act number 8 of 2017, and we'll be very happy to answer any questions at the end of this discussion if you have any. Thank you very much for your time, and we look forward to some questions during this.
Thank you.
Thank you.
Thank you, sir. I think that explanation with regard to the law and the amendment clearly set out what changes came in. And there was also some good advice for counsel there with regard to how issues should be framed and some of the common mistakes that counsel make. Thank you, sir. And our third panelist today, and our final panelist, Mr. Murshid Maharov, who will be speaking on the issue of how issues connect with the final judgment of the judge. And with regard to, we discussed the aspects with regard to the framing of issues, and initially the law with regard to the amendments and issues. But now we come to the part where it connects up with the judgment. So Mr. Maharov will be speaking on the questions of how issues are considered in the final judgment, and what are the effects of issues being considered, how they are considered, and what relevance they have, and what effects they have where an issue is not taken into consideration in the final judgment. Therefore, sir, I would like to invite you to speak on that area.
Thank you, Shamir. And yes, good evening to all. And it's very nice to be with a panel or two other panelists who are with me at the law college at the same time, and also my junior Shamir as a moderator, and Shamir also was my convener at the National Law Conference. And so it's so nice to have you all. Nice to be in the panel with all known people who are closely associated. Right now, on this reasoning of issues. Now, let's look at what is the reason, what is the idea behind, what is the rationale behind raising issue. Okay, when in a civil matter, the plaintiff comes to court with his story, filing the plaint, and the defendant with the answer. So now, all those averments, all the matters raised by the plaintiff and the defendant need not be investigated. There are matters which the parties are not agreeing. So if the parties agree on certain matters, those can be recorded as admissions. Then the other matters, the whole idea of raising issues is to crystallize the dispute between the parties. So when it comes to, so at the end of the day, the issues have to be answered by the judge. So it is the duty of the court to frame issues. Though the plaintiff's counsel, the defendant counsel formally raise issues, it's the burden is on the judge to identify the dispute between the parties properly. So so the court should monitor the framing of the issue, and court should identify the real dispute between the parties. In other words, the dispute had to be crystallized. Now, there are several judgments which have held that once the issues are settled, the pleadings receive a backstage. Pleadings are not important. So then whatever that you have stated in the plaint and whatever that you have stated in the answer, those receive the backstage, and only the issues are considered. Now, the previous speakers have touched on the modality of raising issues, the amendments to the law, and all those. Now, once the issues are raised, the judge has to consider the issues and give a judgment. So now the judge has to answer each and every issue. If the judge is finds it difficult to understand the issue due to ambiguity, or the issues are not clear, then the judge he can on his own reframe the issues in order to explain the issue and come to a proper finding. Now, if you look at section 187 of the Civil Procedure Code, it clearly says the judge has to make a concise statement of the case, the points for determination, the decision thereon, and the reasons for such decision. And the opinion assessors shall be prefixed judgment signed by the assessor. Now, so it's very clear that judge has to give reason. In the case of, this is a very important case, in the case of Varnakula versus Ramani Jayawardena, Ramani Jayawardena reported in 1991 SLR 206. So it was held that every evidence, all the evidence relating to each and every issue must be examined properly. Then thereafter, judge must evaluate and consider the totality of evidence. Now, for an example, if the plaintiff has raised 5 issues, the defendant has raised another 6 issues, the plaintiff, every issue raised by the plaintiff must be examined considering the evidence led on the said issue. Likewise, the defendant's issues, every issue raised by the defendant must be considered looking at evidence, or consider the evidence led before him, and must evaluate that judgment also held that their answer without giving any reasons is not in compliance with section 187 of the Civil Procedure Code. Now, the judge, without giving any reasons, at the end of the day, if he answers, simply saying yes or no without examining, without analyzing, so this judgment has held that will not be in compliance with section 187. So now, then the judge does not give a reason, the judge does not analyze each and every issue, that paves the way for a aggrieved party to make an appeal against the judge. We see most of the appeals, my other panelists also will agree with me, the grounds of appeal, when you set out grounds of appeal, one of the main grounds is the judge not considering the real issue, the real issue before the court, or the issues raised by the parties. So now, when the judge doesn't consider the evidence in relation to the issues, that paves the way to make an appeal against the judgment. Then also, when raising issues, the judge, it's a duty of the court, judge must look at the totality of he must look at the entire case. And with the latest amendment, and the previous laws, it was a case, the issues need not confine to the pleading. Issues need not confine to pleading. Court must look at all the documents before. I mean, for example, the documents attached to the claim, the documents attached to the answer, and how, where the parties have accepted those documents, and if there were any points to be taken, or any points to be considered from the documents that were attached to the claim or the answer, also can be considered, and court can raise issues based on those documents without confining the issues only to the plea. Then that is in this case of 86, report in this case of 86, 3CLR case where halfway through, the defendant raised an issue, and so in that judgment, it was held that when parties are allowed to raise issues at any time, even halfway through, midstream the trial, halfway through, the parties can raise an issue. But there is clearly stated, if the judge rejects an issue or accepts the issue, he must give reason. He can't postpone the reason to the end of the case. If he rejects an issue, he must give the reasons why it is rejected without keeping the reasons to be given at the time of delivering the judgment, at the end. So now, when the issue, the duty of raising issues is on the judge, because a judge is going to answer the issues. So it's like a basically questionnaire put forward to the judge. So when judge can't simply ignore the terminology used by both parties when raising issues, he must consider it, since he is going to answer. Then thereafter, it's the duty on the judge in terms of Section 187 of the Civil Procedure Code to consider all the evidence in relation to the issues raised and analyze it. Then thereafter come to a proper finding. The judge not coming to a proper finding of the issues or answering the issues properly without considering the evidence, that is not in compliance with Section 187 of the Civil Procedure Code, and it can be set aside in appeal. Then all these amendments, I think my friend Chanak touched on the latest amendments, and Puvi also touched on the latest amendments. Now we have to, without raising it in open court, now we have to tender written issues and admission. And when it comes to admission, when you're admitting certain facts, the counsels have to be very, very, very careful, because once a fact is admitted, the court need not, the parties need not lead evidence on that matter. So when you're admitting, you have to make sure that whatever that you're admitting is not detrimental to your case. So because once it is admitted, and there's no necessity to lead evidence, so that if you admit certain things which can go against your case, then that will be very detrimental to the party who is proposing to admit it. So we have to be careful when it comes to admission, and judges, and I had touched on judges' duty analyzing those issues, and any other matters can be clarified during question and answer time, and question and answer time. So thank you very much, Shamir.
Thank you, sir. It was very nice listening to you again. Took me back to memories of first learning about some of these, and has always been nice to keep learning, as I would always say, because there's never enough knowledge when it comes to the practice. So now we move on to the section with regard to the questions and answers that are put to the panelists. Remember, for those of you who are joining a seminar for the first time, any questions that you would like to direct to the panelist, you may type them in the chat box, the Q&A chat box, and them. If you would like to direct them to any specific panelist, you may refer that question to that panelist, or I will put it to the panel in general. We already have a question that has been asked by one of our participants, which is, what is the effect of a party's failure to file the proposed issues before 14 days of the pre-trial? Would any of the panelists like to take that matter up and speak? I think I would put that question to Mr. Puvidaran. Would you be able to enlighten us on that, sir?
Yeah, now that new section, new amendment, is that it warrants the parties to file the issues and admissions and also the written issues and admissions and list of witnesses to be filed within before 14 days of the pre-trial. But failure to do, the section 142C says it is the diligence, fail to diligently prosecute his or her case is set out in paragraph, section 142C of the amendment. So where it says you fail to prosecute, the consequences are set out there, and the trial judge can decide, the pre-trial judge can decide that he has failed to prosecute diligently, and the consequences follows accordingly, that either it will be fixed, what you call ex parte, or sometimes, but generally nowadays it is not happening.
Thanks to COVID.
Sorry? Huh?
Thanks to COVID.
Yeah.
Thanks to COVID, none of these things are followed.
So it is not followed, and that is that. So diligently not prosecuting. So then the consequences follows that either ex parte or sometimes the judge can, because there is no mandatory, strict mandatory. Yeah, it is not mandatory, and some places we see the judges, they allow that, and some places it is not properly even understood by the lawyers also. So still that is not there, but it can be fixed for ex parte. So we have to be very careful. We should file that in advance before 14 days, and so that is better.
Shamir, if I may add to what Puvidaran said, what Mr. Puvidaran said, there is a discretion given to the judge in this. In 142C, there is a discretion given to the judge. The judge may conduct the pre-trial hearing may taking into consideration all appropriate circumstances. So that's a very wide discretion given to the judge to consider all appropriate circumstances. So as Mr. Puvidaran very rightly said, we have not seen in the recent past any cases either getting fixed ex parte or getting disposed of due to this, because the judge has the discretion. But I think as practitioners, we must not take it for granted, but we must somehow ensure that this is followed to the letter.
Thank you, sir. Now, Mr. Fernando, you mentioned in your speech or on your presentation that there are instances of counsel framing every single paragraph as an issue, and thereby it's sort of going on. In addition to the mere time wasted and it being arduous to record, are there any other disadvantages that may arise to that particular party by the counsel unnecessarily raising extremely long or a large number of issues? Will it in any way affect or prejudice his case?
Thank you, Shamir. That's a very, very vital and important aspect. As mentioned by Mr. Maharov, it is the judge, as you know, judges are also human beings. And when you can resolve something with about 5 issues or 5 questions, and if you put in 25 or 20 questions or issues, you're going to divert that judge's attention to something else, which is not the crux of the matter. That is the reason we have to be very careful when you're framing the issue that we concentrate and focus on the crux of the matter or the main item to be adjudicated by the learned judge. Because otherwise, the learned judge may give his attention, to something which is not important, and then you might lose your main focus or the main case. So that is the reason the counsel have to study the brief beforehand. Counsel has to go through all pleadings of all parties beforehand and then decide what are the areas, what are the matters, what are the elements he's going to raise as issues, so that he can get the 100% attention of the judge on those particular issues. So that is the reason I would urge counsel not to, some counsel as a caution or as precaution, do that, because they think that if they miss one of the paragraphs, it might be a problem. But as Mr. Maharov very rightly said, it is not required, because the elements in the pleadings is a story you're going to tell the court and tell your judge and tell the opposing party. But the issue is not the story. Issue is the crux of the matter to be decided upon, to be adjudicated by at the end of the trial, after leading evidence, documents, all that. So therefore, I think we should get into the practice of concentrating only on the main areas and RESA issues or FREMA issues, only on those.
Thank you, sir. Thank you very much.
Can I also add to Mr. Fernando's comments? And yeah, now on the other hand, that is why the burden is cast on the judge to frame issues and control the issues. So judge must know that at the end of the case, that he is the one who's going to answer the issues. If he had about 50 to 60 answers, if the parties have raised about 50 to 62 issues, 50 to 60 or 50 issues, the burden is on the judge to answer all the issues. So because the judge must crystallize, he must have control of the issues raised and confine it to the main dispute between the parties. And also, as Chanak Fernando pointed out, as a habit, I see most of the counsel, raising all the averments as issues which are not necessary. You can lead evidence on all the other matters. Can lead evidence on that, and those are not issues between the parties. Those matters can be covered by leading evidence.
Thank you, sir. I think now the case of Hamid versus Qasim very specifically made a statement that issues can be raised at any time in a trial. Now, we regularly see at a point of one of the parties leading evidence. In some occasions, the counsel or the opposing counsel may raise an objection saying that he is leading evidence on matters not raised as an issue. And sometimes the judge may direct the party to raise an issue. My question to you, Mr. Maharov, sir, is now in the event that no such objection was taken by the opposing counsel and one of the parties did raise evidence with regard to matters not covered by any of his issues, and he relies strongly on them in his written submissions and even in the judgment. Does that have an effect on the final judgment? If there was a lot of evidence raised, what is the judge's role in that? What is the parties with regard to their written submissions? And does that give a good cause to appeal the judgment in the event that had happened?
Now, Shambi, that Hamid versus Qasim case, reported in 1996, I believe, Justice Ranraja's judgment, and that is on section 149 of the Civil Procedure Code, and where he set some guidelines to allow parties to raise issues halfway in the middle, after settling issues at the beginning, then if there are any issues to be raised, and he set down the criteria for raising additional issues. So that those additional issues, according to that judgment, those issues have to have a relationship to the main issues. It has to be connected to the main issue. You simply cannot raise anything, totally outside the initial issues settled between the party. And to answer your other question, when matters of evidence or leading evidence raised as an issue halfway through or whatever, if the other side doesn't object, it's back again. It's a duty of the judge to have control of that thing. The judge can straight away refuse. He can reject it. He can reject it, saying that those issues are not relevant and that can be covered by leading evidence. So then also these, yes, then, I think in that case, the case that you referred, Justice Ranraja also held that setting out a guideline to raise additional issues, that he held that it should be exercised only where it is necessary to do so in the interest of justice. So that is the whole idea is to primarily the primary objective is to arrive at a correct decision. Those issues were allowed. Those additional issues are allowed after the initial issues were raised halfway through during the trial. Yes, Shamir.
Thank you, sir.
Add to that, there is one that if it is a pure question of law, the judge can raise it also before the judgment until at the time of judgment also. But only thing is, there is another point that could be raised is that the parties must be, whether it is raised by the judge or whether it is raised by the parties, both parties must have the opportunity to make submissions on what is going to be decided. So even if it is a pure question of law, one can argue it must be before deciding on that matter, the parties must be known, must be made to know, and they must be given a chance to make at least a submission on that. That argument also can be, in a proper case, can be put forward, because parties must be heard, audio from partum must be there. So that is also there. It has not been considered. It has not been the question in that case, I think. Yeah.
And
Thank
also,
you.
Shamir, and also, if you are raising additional issue halfway through, there must be evidence. If based on the evidence, and since we go back to the fundamental thing that issues are not confined to pleading, but halfway through leading evidence, if new things come up, and the judge feels that those are important to decide to arrive at a correct decision, then considering the evidence led, the judge can grant parties, the judge can frame extra issue, additional issue.
Thank you, sir. There's another question that has come by one of our participants. The question reads as follows. Is it mandatory also to file the list of witnesses and documents 14 days before pre-trial, as some documents and witnesses may not be necessary after the admissions and issues are raised? This question has been raised, asked in view of an obiter dictum or sort of a comment made in the course of Mr. Fernando's response. So, sir, would you like to take that question?
Yeah, section 142A specifies that we have to file within 14 days and then prior to 14 days. And therefore, it will be mandatory to file it, because otherwise we will not be able to bring it in later. And as you know, the list of witnesses also has to be filed within prior to 14 days. So therefore, what generally happens in practice is the admissions, the issues, the list of witnesses and documents are all 14 days prior, in order to avoid any kind of problem for giving unnecessary to the opposing party to take objections. And then because section 121 and 174 deals with filing of list of witness and documents, and section 142A on the amendment deals with the issues and admissions. So therefore, we amalgamate both, and it should be done. That's my belief as per the current law. There's also another question on the chat box, Shamir.
Yes, there is. There are two more questions. Hold on, I will do this. The first question was, how do you raise issues through documents? Could this be done? If so, could you please elaborate with an example? Mr. Puvidaran, sir, would you like to take that on?
Yeah. Now, sometimes say we will consider there is a lease agreement. It is now terminated. We have not pleaded that in the pleadings, but we have pleaded and marked that document in along with the plaint. So that document will speak when it is going to, it has been terminated. It will say on this particular day, this terminates. So on that issue, since though there is no pleadings, there is no government set out in the pleadings, but the document will carry when it is terminated. So you can raise an issue on that, whether that lease agreement has been terminated or has come to an end. So that in that manner, you can raise issues. So those are the issues. Even evidence also, as Maharov said, having laid the evidence on a material fact, you can raise issues thereafter, because considering that evidence, you can raise issues. So this is one of the example that I could give you.
Thank you.
Shamil, now on this question that the previous one that you posed to Mr. Fernando,
Yes.
and that is a gray area. There are a lot of confusion. There's a lot of confusion at this moment whether the list of witnesses also should accompany the issues and admission that has to be filed 14 days before the trial. Now, as Mr. Chanak Fernando pointed out, the section he referred to section 121 of the Civil Procedure Code, where the requirement is there to file the list before 15 days. Now, section 121 is not amended. Section 121 is not amended. So therefore, now one can argue the list has to go before the trial. So now, whether it's trial or pre-trial, that's a question. Now, on the other hand, now with the new amendment on the date of the pre-trial, court there's an onus on the court to consider all the pleadings, documents, and everything on the first day. So now, if that is the case, then the court should have all the court should have the list of documents and witnesses to consider everything. But there is a confusion now whether that has to be filed. The list of witness and documents have to be filed before 14 days of the pre-trial, like in the case of issues and admissions, and also whether it has to be filed after passing the pre-trial stage. Now the pre-trial stage also, with the latest amendment, once the pre-trial is concluded, a date has to be given, a call-in date has to be given to fix the date for trial. So one can always argue, yes, once the pre-trial is over, then there's a call-in date to fix the matter for trial. So because of that, the list always can go later. But on the other hand, the argument is then the rationale behind section 100, the new 100, section 142, to consider all the materials and consider the entire case, the trial of the pre-trial, then parties should file the list of witness and documents prior to the date of pre-trial. So my opinion for the moment, since there's little confusion, and I will also go with Mr. Chanak Fernando's opinion that we should file the list of witness and documents also with the issues and admissions. Then the court can consider court can consider all the issues on the date of the pre-trial.
Thank you, sir. There is another question by one of the one. It is, can issues be raised at the stage of appeal? So the question is, at the stage of appeal, is there any way to raise or even change the nature of the issues at a later stage that may not have taken place at the earlier part of the trial? Mr. Fernando, would you like, is there a possibility to do that on any scale?
I would say no, because we have to be curtailed to the brief of the district court. So my opinion would be that you cannot. I wonder whether Mr. Puvidaran or Mr. Maharov has any other opinion on that.
If it is a question of law, your question of law, even at the stage of appeal, court might allow that, because there are few judgments which are not very on the thing, because these Vigneshwara Murthy versus Singaharan in 1995, 1 SLR 339. It was said the special leave is granted on a question of law which questions and no other issues can be raised in the appeal before the Supreme Court. So that is where it was said there, but there are some other judgments where Kandasamy versus Sinnathambi in 1985, 2 SLR 2, where it says that is a bit of a gray area, but my view is sometimes if it is a pure question of law and there are materials that have been led in the evidence and the case is there, the court might entertain, might allow that.
May I add something to that, Shamir?
Yes, sir.
Now, whether it's in the form of an issue for the trial, not in that sense, when in appeal, a question of law can be raised for the first time in appeal, but that question of law should be connected to the main issue in the case, not a question of law which is completely outside the issue that was that was before the court. So that has to be some connection to the main issue in the case. So for the first time in appeal, a pure question of law can be taken up.
So if I am to put it clearly, if it's a matter or a question of law, that would be raised and that would essentially make itself into the district court case as part and parcel of the original district court terms of reference. Am I correct in understanding it that way, sir?
Yeah.
So
yeah. That is the judgment. Wait a minute. Okay. That is at 48 NLR is 48 NLR Talak versus Gangodavida. So that is 48 NLR case. So that is so in that case only it was to decide that a question of law can be taken up for the first time in appeal, but it has to be connected to the it has to be a pure question of law connected to the main dispute that was in district court.
Now, sir, if we are to assume that this would be the first appeal, we go from the district court to the civil appeal, and at the stage of the civil appeal, this question gets in as a question of law, and as we discussed, it will get into the sort of part and parcel of the original district court action. Now, upon the second appeal, at the point that it goes to the Supreme Court, will that question of law be considered at the Supreme Court stage as having sort of being part and parcel of the original terms of reference that came from the district court? Or would it be considered in appeal separately as a matter that was taken up at the civil appeal in either allowing the appeal or dismissing it?
So now if the matter goes to Supreme Court, whoever the aggrieved party on this new question of law will take up the position saying that the civil appeal court should have taken or should not have taken up that question of law. So, that also can be argued in the Supreme Court. So at the end of the day, the Supreme Court being the final court, they can review the entire thing, whether this question of appeal should have been taken, whether it was correct to take up that issue at the stage of first appeal or not.
Thank you, sir. Another issue I think we can discuss with regard to the balance of framing of issues between a plaintiff and the defendant. Now, we are aware that for a plaintiff to have established his case, he will go into a detailed level of description in his plaint and therefore raise very specific questions. But we see in money recovery matters in certain occasions, counsel filing answers, or even in a certain matters, even with regard to other matters, where the answer sometimes filed in the last moment with no time to go into a detailed defense, just denying all the averments of the plaintiff and denying all the averments, and then just going on to request court to dismiss the action of the plaintiff. This might have been an instance where the plaintiff has severely sort of gone into detail in his plaint. Now, in those instances, the issues for the defendant may just be one issue: should the plaint be dismissed or something. So does that unfairly affect the parties? Because by just that issue, does that allow the defendant to sort of bring a variety of different defenses and unfavorably balance the trial in favor of the defendant in instance like that? Or is he limited by not taking up a detailed enough defense and therefore not framing issues on all aspects of his defense? If I may put this to Mr. Puvidaran or Mr. Maharov, sir, if you may answer that.
Yeah, Puvi, you're good. Okay, Chanak, now it's like this. Now with the new amendments, now basically then the defendant in the case, I mean the situation that you have cited, the defendant puts the entire burden on the plaintiff.
Correct.
Entire burden on the plaintiff. Now then plaintiff, anyway, the plaintiff, whoever in a money recovery action, whoever who goes to court, and he has to prove the case. The burden is on the plaintiff to prove the case. But on the other hand, with the new amendments that came up recently, now if certain matters need not be proved, if the defendant has unnecessarily made the plaintiff to prove, say for an example, official documents like certified copies of police entries and certified if some documents produced from government authorities with certified copies. So if the defendant still wants the plaintiff to prove them, then the defendant has to pay a penalty. He has to pay the cost if those documents proved. So this unnecessarily delaying, unnecessarily putting the burden on the plaintiff, some sort of relief granted to the plaintiff. And of course, the defendant has a right to completely deny everything, but the court will at the end decide whether he had unnecessarily put the burden on the other. And the new amendments have allowed the plaintiff to recover compensation for wasting time and money in proving documents and proving his case. Yeah, Puvi, can add.
Yeah, and also there are, as Maharov said, this new amendment also bring that 440 or somewhere. It says that whether you can, whether documents that are filed original and all those things, those documents are deemed to have been, admitted or something to that effect. 440, I suppose, 440C. It says proof of documents unnecessarily, unless it is impeached. And there is other one is that even before that also we have this proof of documents where we can ask the admission of the documents whether they need to be proved. If he wants to be proved, then he has to pay the cost of proving that. And the other matter is that this is only a balance of probability we all look into. So if the original is there, you don't require to call for each and every document to be proved. But if the original is there, if the signature is there, only you have to tender those things. Because if it is proved on a balance of probability, then the court will have to decide it, because when there is no defense also, that also will be given, should be considered. So because he doesn't have a defense, only he is denying. So he won't have any issues raised. So what will happen is the plaintiff will be raising all the issues and he will have to prove that. And once it is proved, basically, as earlier said, the basic material, the dispute, the issues are proved. So then the balance of probability, it should be considered. So I don't think that, this is what I understood from your question. So I don't know whether I was little, I couldn't properly gather your question. That is why I couldn't answer that properly also. So is it okay, or you want further clarification?
I believe that that answered the areas. Basically, on the issue of the burden of the parties in proving their case and whether the balance favored one party over the other, where there was a sort of a discrepancy in the detail of the issues filed. So I think Mr. Maharov and yourself clearly got to that part. I believe we are coming towards the close of our time, and before we conclude,
Samir, there was one question on the chat where
yes.
they had asked whether
Yes,
parties
definitely
should
the
be
question
present.
has just come up on the chat. Yes, not on
Yeah,
the
so
Q&A.
it's 142C. 142C talks about the parties being present on the pre-trial date. So that's the section they should refer to. 142C of the amendment.
The question on the chat, of course, was that on the day of the pre-trial, the parties must be present or no need. Is it mandatory under this amendment? That was the question.
Yes, correct. So under 142C, and also in practice, we have seen that judges want to talk to the parties and see how best matters could be resolved as well. And 142C specifically states that parties should be present. But of course, you can also take up the position that a proxy is given to a registered attorney, instructing attorney, and instructing attorney is present. So that's another way where you can say that the party is present as well. But of course, in practice, courts prefer to have the litigants themselves so that they can try to resolve or settle the matters in dispute.
And here to that 142DG also, to assist the parties to come to a settlement. So for that also judges wanted the parties to be present, but as you said earlier, again on the other hand, the proxies are given and we have the power to assist the court at any time. So
before I thank you, sir. Before I hand this over back to Mr. Tanuja Meghawat of the BASL, may I just place on record what a pleasure and a privilege it has been for me to share in this experience moderating this discussion with Mr. Puvidaran, Mr. Chanak Fernando, and of course, I would like to say I kept my personal favorite best for the last. My lovely senior, the man who taught me everything on civil procedure, Mr. Murshid Maharov himself. And thank you, sirs. It has been lovely sharing this seminar with you. And I would like to hand it over to Mr. Meghawat.
Thank you, Shamir.
Thank you, Shamir.
Thank you, Mr. Shamir Zawahir.
Thank you, Samir, for a very professional job done.
Thank you, sir. And I would like to thank all of our participants today for taking part. And once again, place on record, thank you to the panelists for taking time off this on Saturday evening at a time where they would like to take their end of the week break to share the secrets of the trade, so to speak, with those around them and pave way for a new group of juniors to learn from their experience and their knowledge on the matter. Wishing users and our participants a very good Saturday and a happy long weekend for those of you who haven't fixed matters on the gap day, Monday. And if you have, I hope your matter finishes soon and then you will get to enjoy the rest of the weekend. Good night to all of you and thank you once again.
Thank you.
Good night. Stay safe and take care.
Good night.
Thank you, Mr. Shamir Zawahir. On behalf of the Bar Association of Sri Lanka and the Seminars Committee, I would like to thank Mr. Vivekanandan Puidaran, President's Counsel, Mr. Chanak Fernando, Mr. Murshid Maharov, and Mr. Shamir Zawahir for this very informative and valuable session on framing of issues in civil actions. I would also like to thank all of you who joined us through Zoom and YouTube and for the questions that have made this webinar an interesting one. Thank you, everyone. Do join us next Saturday at 5:30 p.m. for the 63rd webinar in this first webinar series. Stay safe and good night.
Good night.
Thank you. Good night.